The House Families and Veterans Committee will come to order. Would the clerk please take attendance?
Chair Schmaltz.
Here.
Representatives Wozniak.
Here.
Fox.
Present.
Johnson.
Here.
Thompson.
Here.
Pavlo.
Here.
Wolford.
Present.
Young.
Here.
Burns.
Here.
Reingens.
Here.
Song.
Present.
Madam Chair, you have 11 members present, a quorum.
Thank you, Mr. Clerk. Representative Wozniak moves to adopt the minutes of the August 26th meeting without objection. So ordered. So our first order of business is to hear testimony on House Bills 4727 through 4729. The committee will stand at ease at the call of the chair.
Meeting her testimony on House Bill 4727 through 4729.
Thank you, Chair and Committee. I'm happy to sponsor this bill package with my colleagues, Rep. Jimmy Wilson and Representative Kurt VanderWall. Protecting our most vulnerable citizens is why I'm honored to serve as state representative and chair of the Committee of Families and Veterans here. I'm often reminded that the measure of our society is how well we safeguard those who cannot fully protect themselves. The elderly, disabled, and others who face challenges that make their dependent on others for their care, something we really have to take a look at. So it's time to put some common sense guardrails into Michigan's guardianship system by requesting who has oversight and control of these vulnerable individuals. When a probate court judge places someone under the control of a professional guardian or conservator, it's often because there are no other options. Families may be willing to help, but lack the ability or they are shut out entirely by a system that gives immense power to elected judges. In some cases, this decision is made without the family's input or against their wishes, yet the consequences are deeply personal and far-reaching. Unfortunately, Michigan's current system leaves far too much room for abuse, neglect, and financial exploitation. Today, professional guardians can be appointed by probate courts with no certification required, no formal training, and no criminal background check. That means someone with no credentials or even someone with a troubling history can assume total control over another person's finances, healthcare, housing, and legal affairs. Media stories from across the state make it painfully clear that reforms are way overdue. This legislation would establish a strong licensure process for professional guardians and conservators in Michigan. The plan creates a state-based licensing system to ensure guardians are properly vetted and held to higher standards. This proposal would require guardians serving 3 or more unrelated individuals to obtain a license through the Michigan Department of Licensing and Regulatory Affairs. They would first need to pass a nationally recognized exam conducted by the Center for Guardianship Certification, which is considered the gold standard and used by more than a dozen other states. Additionally, applicants would need to submit to a criminal background check, maintain professional liability insurance, and complete continuing education courses. These requirements would apply to professional guardians only, not family members caring for loved ones. Family guardianships and guardianships of minor children would not be impacted by these bills. So licenses would be issued to individuals only, not businesses or institutions, preserving the personal accountability that this role demands. The goal here is simple. Protect Michigan's most vulnerable residents by ensuring those with power over their lives meet clear professional standards. With these reforms in place, we can restore dignity, accountability, and trust to a system that touches thousands of lives. We need to send a clear message that Michigan does not tolerate the abuse of our vulnerable citizens. I hope you'll join me and the nearly 24 bipartisan co-sponsors in supporting this important legislation. And now I turn it over to Rep. VanderWall.
Thank you, Representative. Thank you, Mr. Chair, Committee. I'm very excited, number one, to be here today and an opportunity to hopefully make some corrections in an area that I really strongly feel need more oversight. So I do appreciate you taking time to hear our testimony on this important issue. My bill amends the Mental Health Code to ensure that people who are in need of guardianship services are being appointed one that is licensed. I have heard horror stories over the years of families that have been hurt and the individuals that have been taken advantage of because of bad actors that are in this space. These bills will make sure that our vulnerable adults are looked after. Specifically, for the first 2 years after these bills are implemented, the courts must appoint a licensed guardian if one is available. But if one is not, they can make an exception for someone qualified who is available. After 2 years, the court must appoint a licensed guardian. These bills prioritize safety and specifically the patient, who will still have the ability to give input to the judge on whether there is someone that they would prefer to serve in that role. It is long past time that we finally address this and keep our constituents safe, so I urge you to swiftly pass these bills, and I thank you, and I look forward to answering any questions later if you have any. Mr. Wilson.
All right, thank you, Mr. Chair and the committee members. Simply put, this will put a uniform system in place here in Michigan. I think as we work through a lot of different legislation here in this chamber, we find different systems that are not standardized throughout the entire state. And so this bill package would do that for our guardianship and conservators. Me and my office, we've met with plenty of individuals that serve as court-appointed guardians and conservators. We've heard their stories, and we know that this is one step in the right direction to better improve the way that the process works here in Michigan. The individuals being served by these court-appointed guardians and conservators are most often our most vulnerable members of our community. Ensuring we have proper standards and licensing and processes in place, these individuals who are entrusted to care for them is crucial, and it's past time we begin looking at this profession professionally. Simply put, my bill in the package, it amends the Estates and Protected Individuals Code, or EPIC, to ensure it references the licensing requirements created under Article 14A of the Occupational Code, which has been established in the other bills in this package. The amendment will ensure that only individuals licensed under Article 14A will be considered as viable court-appointed guardians and conservators.
We do have a lot of people getting ready to testify in this bill, but if you have any questions for us, we'd be happy to take them. All good?
No. Yes, I know. I'm looking around, make sure. All right. Rep. Reagan.
Thank you, Chair. Chair Schmaltz, I was reading the text of your bill, and I understand that your bill talks about creating a board, but I'm trying to figure out where the board members are appointed, or where, is it just staff within the Department of Licensing and Regulatory Affairs? Is that what it is?
Yes, yes.
Okay, so it's not like appointed external people. It's specifically within the department staff whose job it is to look at these licenses.
I believe so. I think that's right.
Okay, thank you.
For Rep. VanderWall, I have a question. You mentioned that the court must appoint a licensed guardian after 2 years, but that is not including a guardian that's already a family member. That's not a requirement. The family member can continue on.
They can. I just want it to be clear that in most cases, if that's a qualified family member and the person has strong input and would like them there, it's making sure that we put the right people, especially, family members a little bit different. Unfortunately, we've seen a lot of people that have violated that even as a family member. So we want somebody that's qualified, somebody that meets the standard, and in some cases, a family member will not have that opportunity.
And for either
or any of you, is there a requirement to report to the court any transactions involving the real property in the ward's ownership?
I think we can probably answer that with the experts that are coming
Right,
out behind
yeah.
us.
Okay.
I don't want to say something here I shouldn't.
Yeah, I think we should wait for the others to talk.
Because, you know, all the horror stories are
Absolutely.
when the houses are sold out from under them. Okay, Chair, you want to come back?
Yep, sure.
Oh, I'm sorry. Oh, we got a few. All right. Rep. Young.
Thank you. Thank you for this important legislation. I just had a couple of questions, but I'll start with the first one because I want to understand more about the 30 hours of continuing education. Who submits those? And if that's something that's better answered by one of the others, I'm fine with waiting for that.
I'm sure other people can answer that for you. Again, we have a lot of people
Yeah.
ready to testify. Right now, there's about 13 states who either say you have to have a license or some national certification before you can be appointed a guardianship. So different states are moving in this direction too. But I think I'll let, like I said, we have a lot of people ready to testify, so they can probably answer these questions.
Okay. Thank you, Madam Chair.
Rep. Johnson. Okay. Rep. Thompson. Okay.
Okay,
That's all
thank
we've
you.
got right now. Committee will go at ease.
The committee will return to order. Next, we'll have testimony from Dr. Bob Powell of Family Services and Children's Aid in Jackson County. Dr. Bob, you can start whenever you want. Thanks for coming.
Thank you, Madam Chair and committee members, for giving me this time to speak about my Guardian program. I had the honor of speaking in front of you about 3 months ago. And I remember your question. I'm ready to prepare to answer it. So Family Service and Children's Aid is out of Jackson County. We specialize in traumatized kids and families. I offer foster care, adoption, drug treatment, mental health services, preventative services, juvenile diversion, parent education, 13 programs like that, but we also run guardian services. My guardian services include 7 staff. We offer prevention all the way through full guardianship. This bill covers the full guardianship. These bills do. So what we attempt to do with guardian services is prevent the need for a guardian. So I have several workers that are community health workers that work with the at-risk vulnerable adults that are referred to us. Our primary referral sources are Adult Protective Services, our local hospital system, and our local community mental health. And they attempt to locate trusted advocates, family members, do a wraparound approach for services, develop a permanency plan in an attempt to not need full guardianship. We look at guardianship as a last resort. If it comes to that, then they must be determined legally incompetent. What that means is they undergo a psychological evaluation, and then and only then would we accept them into our guardian program. And as Representative Schmaltz testified, that then is created through a petition through our local probate court. And then we become their legal guardian, and they become our wards. Essentially what we attempt to do is find the most least restrictive setting for them. It could be in the community. Often it is an adult foster care or nursing homes. Currently, I have about 250 in this program. I do have a full staff of 7 though, so that sounds like a lot, and it is. The actual guardians, I'm not a guardian, my agency becomes the guardian of the individual. So all of my guardians that work with the ones that are referred from the probate court are certified. It is not mandated in this state, but we believe that it is the gold standard, the best practices. They are certified through the Center for Guardian Certification, as mentioned in the bill. What this entails is they have to study, and it's a very difficult exam. They have attempted, a couple of them have attempted to pass it and had to retake. And then at that point, they have to maintain their CEUs. Currently, it's 20 CEUs. Our Michigan Guardian Association, and you'll hear some of my colleagues speak to this, sponsors 2 conferences a year with trainings and keynoters and helping us to plug into what's going on currently and what is considered best practices. So they ensure that we meet our CEU requirements to keep our certifications up. When I spoke to this committee 3 months ago, seems like a lot longer than that, I was asked about accountability and oversight of my guardian services, and I replied that there really wasn't any. And what I suggested was regulatory standards and oversight. And just because my guardians are certified, because that's my standard, does not mean that there is any oversight. That is why I am absolutely in favor of licensing oversight. All of my mental health clinicians have licenses and have oversight. And the rigor that it takes to become licensed. And so my agency wouldn't be licensed, my individuals would be licensed. And part of that is they would need to be certified. This also allows a venue for complaints. If there are issues with anybody that has a professional license, there are steps that can be taken to file a complaint with the licensing board. And then there is an investigation that takes place by the licensing board. And so I believe that this is necessary given that there is no oversight at this point throughout the state of Michigan. Are there any questions?
Thank you,
of me?
Dr. Bob, for your testimony. Are there any questions for, okay, Rep. Thompson?
Thank you, Madam Chair. Thank you for your testimony. That was my question when it was related to how do you terminate these positions when an individual has become able to care for themselves or there's a guardian that gets a hold of them. So it sounds like when you create the licensing aspect, then you can use Laura to file a complaint. So without that licensing right now, how difficult is it for family members or an individual to get that conservatorship or that guardianship removed without this process?
The process would be they would petition the courts for changing guardian, and then the judge would oversee what is in the best interest of the individual.
Is that currently happening in Michigan?
It does in Jackson, yes.
Okay. Okay, thank you.
You're welcome.
Representative Young?
Thank you, Madam Chair. Thank you for coming back.
Thanks for having me,
Thank
and
you
I'm
for-
thrilled that there is some legislation around ACEs because we talked about the ACEs
Yes, that's right. we
that I
did, we
provide.
did. Yes, thank you. So, quick question. I was looking over the legislation, and these are good things that we're addressing, but I'm also still a little bit concerned about the number of individuals that each guardian is assigned to. I think you said right now you have 250 individuals.
Correct.
And 7 guardians, so that's around 35, 36. Is
May
that
I
right? Am I doing the math right?
But of the 7, unfortunately, I only have 2 that are certified to actually do what we call guardian of the persons. So we have conservatorship in this bill, oversees that as well. And I have business individuals, office managers, and an accountant that oversees that. And then the other two are in prevention. And so doing the math, my guardians have caseloads of 125. Yeah, it's a lot.
That's a lot. Okay.
Lot.
Well, you have the gold standard. How do you feel? How you feel about that? Are you working to get more certified to
I'm working
lower
to
that
raise
number?
funds to get more staff to do that. Yeah.
We're working on that, Bob.
Yes, we are.
Rep. Bosniak.
Thank you, Madam Chair. Good to see you again, Dr. Bob.
Thank you.
You did mention that guardianship would be the alternative of last resort.
Correct.
So on the priority list of appointments, you'd still be at the bottom? But when the court has to consider family members, other interested persons, you're at the bottom?
Wow, the way you say that. What I meant by last resort is that we attempt to look at all least restrictive options to help them not need a guardian. So we locate trusted advocates, family members, and such. As far as the court's decision-making, often there is not competing parties, so I really can't answer that honestly.
Okay. All right. Then I had a question about real estate.
Yes.
Do you know if there's going to be a requirement to report any real estate transactions?
I did hear that, and yes, we do accountings to the court
Right.
about all properties.
But before they're sold?
No, we do not.
Okay. And then if one of your certified people are accused of or found to be misappropriating funds or anything, then they would not be able to serve the under 124 cases wards at all?
Well, the way the bill would read, they would need to maintain their license. And so I require certifications and licensing to keep your job. And so they would no longer be employed by me if there was any misappropriations.
All right. Thank you.
Yes.
Rep. Johnson.
Thank you, Madam Chair. Thank you for joining us again. 2 questions. You have a high bar standard here. We know that it's been recognized that guardians are not paid very much.
Correct.
But they get, for your guardians that are certified and vetted through your system, they're paid through the regular process, the small stipend, plus you're able to offer them a little bit more to make it worth their while? Or how does that work for payment for them?
By standards, we can only bill $83 a month.
Okay, so that's capped?
Yes,
no
it
matter.
is.
Okay.
That's regulatory.
And you can't, through your organization, pay them additional?
Absolutely. I raise money.
But you can pay them, so you can pay them an additional amount from your organization, correct?
I'm not understanding who I'm paying.
The guardian.
They're they're staff, so they get an hourly wage.
And some of them are guardians?
Yes, and some
Okay.
of them are guardians.
Okay, all right. That's great. I think
Yeah,
that's
so
great.
the 83, which does not cover costs, goes towards the running of the program.
Right, okay. Then the other question, you mentioned that a family can petition the court to challenge a guardianship or such like that. When and if you've seen this, how many times has the family gotten the guardianship back to the family when it's been challenged through the court system?
Challenge is a strong word because that's rare. Typically, if a family member does come forward, then we help the process along because we think that that's more appropriate than a professional guardian if we have family members that would care for their loved ones.
Let me ask it another way.
Okay.
I appreciate that. I've seen situations where the family was never notified that the court was going to
Right.
assign a guardian to somebody. They were left out of it. They never got a notice, et cetera. Once they found out, they petitioned the court that we, the family, would rather care for him in the way that he's already instructed us. Given XYZ situation, they would like to be in this nursing home with, et
Sure.
cetera. Have you ever seen that kind of a situation where then you could work with the family after the fact?
The standards are, you have to publicize, so that, now, does all family members notice, oh gee, you know, my loved one is up for a guardianship? No. But again, you know, the way I've designed my guardian services, our community health workers, that's their job, is to try to find loved ones and family members and trusted advocates, kinship, to try to avoid needing a guardian. That's the last resort piece. It is rare that I have seen family members contest where the judge would not rule in their favor. By the time it gets to that, we're pretty familiar with what's going on with the family dynamic, and we absolutely will assist in changing guardianship if that's appropriate. Did that answer your question? All righty.
Thank you, Dr. Bob, for coming again and testifying, and thank you for all you do in Jackson. We are very fortunate to have you.
Thank you.
Thank you. Before we go on to our next testimony, Rep. Reingens, I just wanted to clarify, the board is appointed by the governor, just like in the rest of the occupational code. So, okay. Now we'll move on to Georgia Callis and Amy Kreidich from the Michigan Guardianship Association. You can start anytime.
Good afternoon. Give me just a second. I'm not great at reading off of paper. I'm a teeny bit
Push the
nervous.
button there for the,
Bob left it on.
okay.
So, thank you, Chairwoman Schmaltz and members of the committee for this opportunity to testify before you on these very important bills. We'd like to start by singling out Representative Schmaltz for our immense gratitude for tackling this issue in partnership with our organization. My name is Georgia Callis. I'm an owner of a guardianship company in southeastern Michigan, predominantly Wayne County, and I'm the current president of the Michigan Guardianship Association. I've been a professional guardian since 1993. With me today is Amy Kreidich, also a professional guardian based in Oakland County, who has been serving clients since 2003. Even though it's not required, I took it upon myself years ago to get certification. Amy has also obtained her certification from the CGC. We're here today on behalf of the Michigan Guardianship Association. MGA is the premier initiator of the advancement of legislation reform, guardianship licensure, education, and the promotion of best practices. MGA and its membership have supported many pieces of good legislation over the year, and we proudly fought back against bad legislation that would have done more harm than good to a system that's already in crisis. The time to talk is over. The guardianship system in Michigan is in need of reform to protect those that we serve. Just this past week, there was yet another press release from the Attorney General's office about two individuals serving as co-guardians for an 87-year-old woman who allegedly have stolen nearly $1 million from this woman who was entrusted in, whose care was entrusted to them. To be clear, these people were not members of our organization, have never been a member of MGA, have never attended any of our educational conferences, and likely should have never been appointed guardian in the first place. We need to finally shut the door on criminals who prey on Michigan's most vulnerable. We believe the very first step to reform should be to restrict people who can serve as guardian and conservator by requiring to secure a state license. This monumental step will go a long way to weed out bad actors and prevent those who operate without the best intentions and continue to prey on the most vulnerable. Why does this matter? Michigan's most vulnerable citizens, the elderly, the disabled, and those unable to make their personal and financial decisions rely on guardians and conservators to safeguard their financial health and well-being. Yet today, anyone can be appointed as a professional guardian or conservator with no minimum education, no background check, no state oversight. To emphasize this point, my dog groomer has to have a license. My manicurist has to have a license. And in the state of Michigan, you need a license to catch a fish. I can do a do not resuscitate order with no oversight whatsoever. The lack of accountability leaves incapacitated individuals at risk of financial exploitation, neglect, and abuse. That is why the MGA supports House Bills 4727, 4728, and 4729, knowing full well that it is going to be both financial and an educational burden on our membership. I would like to give Amy an opportunity to explain what we are trying to achieve with this legislation.
Good afternoon. The proposed guardian and conservator licensure requirements are as follows. Applicable to professionals only, this will not apply to family members, 21 years or older, earn 30 hours of continuing education in relevant topics, pass the gold standard exam offered by the Center for Guardianship Certification, agree to a criminal background check, and meet professional conduct standards, including have no fraud, abuse, or exploitation convictions, possess a minimum of a high school diploma or GED, and provide proof of professional liability insurance. In addition, the license would only be valid for 2 years. At the time of renewal, the applicant would have to meet similar list of requirements, including consenting to a new criminal background check. I should also point out that with regard to the background check and Lara's processing of the applications, we do not expect Lara's staff to have to read through every applicant's background check to look for entries that would disqualify them from securing a license. That is not our intent. We would expect all applications and supporting materials to be submitted electronically to the department. This process would require an applicant to check a box stating that there is nothing in their criminal background which would disqualify them from being licensed, and this would be done under the threat of perjury if a person were to be dishonest. It is our understanding that this procedure is currently already used for some other licensed professions in Michigan, so the process already works. As was previously mentioned, along with the licensing process, for the first time in Michigan, an oversight board would be created with Lara. That would provide a venue for the general public to lodge complaints against guardians and conservators. This would provide much-needed oversight and accountability by establishing a 9-member licensing board appointed by the governor to regulate and discipline licensees and review and act on public complaints. Create a public website that would list licensed guardians and conservators, as well as flag restricted or revoked licenses. Ultimately, this will help families and probate courts find qualified professionals.
Thank you. In conclusion, by moving this legislation forward, Michigan would join 15 other states with licensing or certification requirements, establish arguably the strongest licensure system in the nation, provide family peace of mind, accountability, and a clear path for complaints, all while preserving the judge's ability to appoint based on the needs of the individual, be that a family member, a licensed guardian, or another party. Passing these bills, the legislature can close dangerous loopholes and create a trustworthy guardianship system that protects the dignity, finances, and the lives of Michigan's most vulnerable residents. Let's make Michigan a safer place to age and live with dignity, free from abuse, neglect, and exploitation. We'd be happy to answer any questions.
Thank you, Georgia and Amy, for your testimony. We do have a question, Rep. Wozniak.
Thank you, Madam Chair. Ms. Calitz, it's an honor to have you here to provide testimony to this committee. I know you've got quite a bit of experience in the industry, and I think we should rely on whatever you say a lot. But a question on the MGA flyer that you guys put out. It talks about the Medicaid rate right now at $83, and there's no cost or no fee cases. Can you tell me how that works in your system, and what can we do to improve that?
Sure. So the $83 only applies if the client is on Medicaid and is in a nursing facility. And we don't get paid by the state of Michigan. We withhold that $83 out of their income, and then we send the rest of the money to the nursing home. If the client lives in a foster care home and their only income is Social Security disability, we're not allowed to take a fee. So it's not, and people say, oh, nobody works for free. We're not working for free, we're paying to work. Because I still have to pay my staff, I have to still visit them, all the requirements for the people I do get paid for, I have to do for the people I don't get paid for. If this legislation goes through and we don't find funding, this whole thing will implode. We can't do licensing without funding.
That was the point of my question. And I'm sure you've got recommendations that can be made to us, so we've got some guidelines as to what should happen. Great. Again, thank you for being here.
My pleasure.
Thank you both again for being here, and we really appreciate all the work that you do in this area. Thank you.
Thank you.
Next, we have testimony from Steve Burnham, retired Kalamazoo probate court register.
Afternoon, all.
Welcome.
I had to write notes down because I like to bounce all over the place. First, I appreciate the opportunity to testify in front of the committee. I'm retired about 5.5 years ago after 30 years with Kalamazoo County. I started out as assistant corporation counsel, and then when community mental health boards were allowed to become separate entities from the county, in 96, 97, I became their corporation counsel, and I did that till 2003, at which point I was appointed probate register, attorney referee, and court administrator for Kalamazoo, and I did that till I retired in 2020. So what that did, one, my wife said I couldn't keep a job, but I retired after 30 years there, but it allowed me to see, sorry, I'm getting over a cold, it allowed me to see the county process as far as how we fund stuff, the community mental health and how guardianship impacts what we do. And then the last 17 years, as a court system, how the lack of guardians or how you monitor guardians. So my entire court career or county career was with Kalamazoo County. In retirement, so I'm not very good at retirement, I have a little niche practice, and I represent about 12 community mental health boards across the state, all the way from Lenawee, all the way up to Dickinson, Iron, Menominee. I'm all over the place. It was one of the nice things that came out of COVID. I can do stuff while I'm sitting in Plainwell, Michigan. So, but what it's allowed me to see too is how Kalamazoo, how we ran our court. I see a lot of different courts and different approaches on how they do this. And what I've always found is odd, and I've talked to other folks and other committees, you got the same court rules, the same statutes all across the state, yet how they are implemented is radically different. So I'm going to testify a little bit as to what we did in Kalamazoo, and then as to why I fully support these package of bills and why we need them. So in Kalamazoo, in fact, we had Disability Resource Services came down after I'd been there about 4 or 5 years. They wanted to come and talk to us. And, you know, anytime, if you will, an advocacy group wants to come talk to you, you're like, crap, what did we do wrong? I must have missed something, because they're not going to come down to talk. They came down, they had done a survey, and it turns out they had been did a survey of other courts, and they were trying to, they noticed that per capita, the number of guardians that Kalamazoo granted was lower than anywhere else in the state. So they wanted to know what we did. So it gave us an opportunity, and these processes I'm about to talk about were pretty hard-baked into how we did services in Kalamazoo. I had an intake worker. Anybody that wanted to come in and file a petition to become guardian, we put them through an intake process, like Dr. Bob said too. If we could find a viable alternative, we would try to assist them, get them connected with services in the community so you didn't have to file a petition. We had a caseworker that also would go out and investigate. A guardian ad litem would be appointed, go out and investigate. All that information would come to the court, and we would have a hearing. I know someone mentioned a little while ago about people not being noticed. We took, and maybe it's again because we were hard baked in, we spent a lot of time and effort to make sure everybody has some family member to try to find them. I also recognize Kalamazoo is a smaller county. Their rural counties create a different perspective than a county the size of Kalamazoo versus, say, a Macomb, Oakland, Wayne. It's just a lot bigger. But part of this is the statute requires that you do this. And all I'm talking about right now is what we did in Kalamazoo to do that. We would search that, and then, as somebody said, I think Representative Wozniak said, there's a process. You have to work through why you're not appointing a family member or other interested parties. So with all due respect to Bob, and I don't mean, oh, he may have left, that they're not the bottom of the barrel, but I don't know how else to say it. They're really the last resort. But we have to have that system, and that is another reason why these bills are so important. Because if we do not have this bottom of the barrel, if you will, or last resort, we're going to have a lot of issues. I know of personally of cases that I handled as a register where we probably changed guardians 6 times. I'm thinking of this one particular elderly lady. We tried every one of her kids to be her guardian. And as soon as we'd appoint one, the others would come in and argue and complain that that one's stealing from mom or doing this. So we'd appoint the next one. We'd do a hearing, do the investigation, do a hearing, and then they would do the same dang thing. So we kept trying because our judge was committed to not having to go to a public guardian. And we have we're blessed in Kalamazoo County, very good public guardians. We finally ended up having to go to a public guardian because we couldn't, but we had tried everything. And that's what the statute requires and the court rules require. I've argued before, part of today's set of bills are part of a layered approach on how we can do this. There's no one particular thing that's going to fix this system. We need SCAO to help enforce uniformly across all courts how the court rules and the statutes are implemented and followed up on. This will bolster that, and actually, if we get the licensure, or when we get the licensure, I want to be optimistic, when we get the licensure, it will allow for a state database too, so that you can't have somebody that gets kicked out in Berrien go up to Alpena and do the same dang thing. And that's what we want to stop, because nobody wants to see this happen to anybody. And there's just an extreme, I've noticed as I'm out, there's deserts out there. The UP, there are no public guardians. And so what we're hoping also is that if we can get some licensure, have folks look at this as a profession, to the question is funding, which isn't for today, but it's part and parcel of this, we can start getting some qualified. Because if you're getting $83 a month, think about what, you can't come up with a business model that would allow you to do that. The other thing my court did, and we did, was we were committed to reviewing petitions once they were in place. I didn't just rely on somebody's self-reporting. I'll be honest with you, in the 17 years I did it, I never, ever, ever received one annual accounting that came in or report on condition award that said, by the way, I locked Joey in the closet, take all his money, and go to Gun Lake Casino. Never got one single report that said that. So they're not going to self-disclose that they're stealing from people. So I was blessed in Kalamazoo County. We had a med school, and we worked with our med school, and M1s, first-year med students, would sign up to come, and we would train them on what to go out. And we went out, every one of ours, every year. We saw every one of our wards. I did not realize how blessed I was in Kalamazoo to have that kind of a resource. And you don't have to do a med school and do that. What I'm saying is there's systems that the courts can put in place to help monitor this. And it really goes back to, we were committed, from the 3 probate judges I had, to myself, to my staff, to my county, we were committed to trying to do this. And with all due respect, and there's a lot of reasons why this wouldn't happen, it doesn't happen in every county. And I now see that now that I'm out all across the state. I think people mean well and do well and try to do the right thing, but it's very difficult. And if anybody's ever been a guardian, it is not an easy job. Ironically enough, about a year ago, my 100-year-old mother-in-law came to my wife and I and asked, she was having issues, and there's a way in the statute you can ask to have a guardian appointed for you. So my wife became her guardian, and what I realized too was, with the way the system's right now, a lot of the advice I used to give across the counter doesn't really work, because it's really a hard job. I can't believe the people at the MGA, I can't believe they do this, much less for what they do it for. I've always thought that there's a process called Judicial Data Warehouse that my court did. The states had it forever. SCAO has, Supreme Court Administrative Office, that any file you've got, all your files are there. So if I'm here in Ingham, or I'm up in Menominee or Iron, I can put a person's name in that wants to be a fiduciary, and it would show that they've been appointed cases. Not that for whatever reason, and I'm sure they have a reason, SCAO has not made that mandatory. Now, I've been retired 5 years. Maybe they've changed that. I really doubt it. But that would be another step, another layer that would go in so that we could track these folks so that they're not leaving one place or other. And that's another thing that's hard baked into this licensure. Once it's there, then you can search a state database and find out. So the state's got to be involved, because with all the respect to individual counties, there's too many other pressures you have as far as what you're doing and how you do that. So I feel like that. And I've long felt that the Judicial Data Warehouse, SCAOA oversight, and the bills we're talking about today are truly a function of won't, not can't. I think we can do this. And as was testified earlier, Laura already has a system in place and a process. It would be really silly to go somewhere else to have a new system. With all the respect, all you're doing is taking out, dog groomer and putting in guardian. And I hate to compare the two because we are talking our most vulnerable people, but it is amazing to me, and I've always found it amazing that my dog groomer, my barber, because you can get a bad haircut, and guess what? In a month it grows out. You get a bad guardian, you're out, and with all due respect, you never get that money back. It's gone. So it needs to be state level. These bills will keep the wrong people from entering the profession. I think it'll drive the profession up and seen it as more a profession. I think there's been a lot of misunderstanding on just how a guardian becomes a guardian. To the best of my knowledge, I do not know of a single guardian firm that has an advertising budget, because they don't. They don't go out and advertise. They're contacted by the court. And with all due respect to the guardians too, when they get a case, it is a case that is really a rolling dumpster fire, because they've either gone through all the family members or there's nobody else there, and you've got a very vulnerable that either APS is brought in, public safety is brought in, or a family member. So in conclusion, these bills are not intended to be the end or all. It's part of a layered process. But we have to do this step to get to the next step to do that. And we got to start somewhere. That's how the journey starts with the first step. I think this would be amazing. The other thing I always find amazing, too, for public guardians, I would ask this committee, when was the last time a profession came to Lansing and begged to be regulated? This may be a first. But that's how important it is to them. And I think it's how important it is, because I could fall going out of here, have a brain injury, and need a guardian. We have to be able to protect the folks that are going to ultimately need these. And this is such an easy lift and such an easy step to start that process. So with that, I appreciate your time. And if you have any questions, I'll try my best to answer them.
Thank you. It's great to hear your perspective. That's amazing. And it is amazing to me that when you think about these vulnerable adults, that we haven't done something to protect them already. And that's why this legislation is so important. So thank you for being here. We do have a question. Rep. Johnson.
Thank you again, Madam Chair. I appreciate your passion for this and all your years of experience. The licensing in Michigan is necessary for so many things, but we all know that there's certain segments of licensing where the test or the training is largely not adequate for what they're being licensed for. It's more a content of, here's all the ways you can go to jail, be fined, and do something wrong. Okay, you know all that, you passed. I'm not trying to be negative, but have you had eyes on the other states' educational component, so we know this is really going to help them be a better guardian when they do get the license?
Oh, absolutely. And I think probably the guardians can speak to it more, especially those that take it. And that is why I believe that it's baked into this legislation that we're not coming up with our own little test, our own little checkbox. We've gone out, and again, I think that's incredible that MGA feels this is the direction to go. The national test that is tested all across. Now, granted, every state has different laws, but they're very similar. And basically, it's all about the fiduciary duty and how do you care for vulnerable adults, and then it's fashioned to that. So I think the nice thing that the test does, and I think this will answer your question directly, is that test is tested. It has been tested itself as to questioning you on relevant issues for being a guardian and for being put in to care for someone. So I think that's why that test is being done versus let's come up with our own little check sheet list. It also allows probably that as nationally, the approach to guardianship, how people perceive it, how they get it, how the national board does it, because then they're getting input from all 50 states. As it changes, our test will change, so it'll stay relevant. If you put a test in now, you know how hard it is to change something once it's baked into a statute. This allows it to float along, and as they change, like all of a sudden, maybe, and just think about how different things have changed from probably 20 years ago when not anything was really electronic, and today, everything's electronic. So you've got to have new standards on how you approach, how you find, how you secure assets and everything that have been changed. So that allows that test. My guess is I have not taken the test. I'm not a guardian. I don't want to be a guardian. Those people are crazy. I can't believe they do what they do. But my guess is there's questions on that, and it updates so that you're staying as current as you possibly can. But also to your point, I know of courts that had systems similar to mine, and you're not going to catch every bad guy because you don't catch every scam. It just, as hard as we work, I swear to God, they work 10 times harder. But this will add in another layer, and it'll get some uniformity across the state, and it'll actually allow us to build it and make it better. And even if it keeps one bad person from going to apply to become a guardian, well, there's a success. The old starfish thing. If you throw them back, one's a start, then you get 2, then you get 3.
Thank you. And I know you meant crazy in an admiring way.
Oh, I work in mental health.
Yes, I know.
I don't just say it, I live it.
Rep. Rankin.
Thank you, Chair. Thank you for being here. So given that you work in mental health and the last testimony mentioned something about these bills being able to establish a process to file complaints against guardians that are licensed, do you feel comfortable comparing and contrasting that with the recipient rights process in mental health?
Definitely.
How is this the same, different?
I think that's a very apt, because anyone that's familiar with recipient rights, Chapter 7 of the Mental Health Code, there's no other profession out there that has that baked into what they do either. That's for another discussion, but that is a very robust system. It's a system, too, I will say, that it is meant to protect the vulnerable folks that the mental health CMHs provide. This would be very similar to that. And I could see that it creates an open venue, because right now what would happen is, unless somebody wants to bring it to a court, and if the court wasn't invested in the first place to do it, with all due respect, they probably are going to say, yeah, but I can tell you, those med students, the first year we had them, we did all our IDDs, developmentally disabled, and the regular traditional guardians. I think we held, in my little county, 10 hearings in which we removed a guardian because of what we found, just in my little county, just by doing that. So I think having a system in place that somebody could feel comfortable calling and doing and have confidence that something's going to happen. Again, now we already threw one starfish back in because they didn't apply because they don't want a license. If they are and they get caught, and if we have a statewide system, they can't go to some other county and become. So all of a sudden now it just keeps mushrooming out.
Thank you very much. We appreciate your testimony. That's a lot of great information.
All right,
Thanks
thank
for
you.
being here. Next, we're going to go to Zoom. We have testimony from Anthony Palmieri. He's Deputy Inspector General and Chief Guardianship Investigator in Palm Beach County, Florida.
Well, good afternoon, Chair, Vice Chairs, and committee members. Chair, is it okay if I share my screen? I had prepared a couple of slides to go along with my presentation.
Yes, you should be able to do that. Is there? There we go.
Okay, and can you hear me okay?
Yes, we can. Go ahead.
Are you able to hear me okay?
Yes, we can hear you.
Okay, excellent. Well, thank you very much for this opportunity to provide information to you based on my experience in guardianship and conservatorship oversight at the local, state, and national levels. My name is Anthony Palmieri, and I serve as the Deputy Inspector General for the Clerk of the Circuit Court and Comptroller's Office for Palm Beach County, Florida. In this capacity, I have personally overseen the monitoring of over 3,000 individual guardianship cases since 2011. My comments today also reflect my statewide role in guardianship oversight and my national role as the 2022 president of the National Guardianship Association. I have spoken around the world on guardianship oversight, and I'm the founder of a specialized education and training course for guardianship auditors and investigators. In Florida's guardianship system, the elected county clerk is responsible for auditing all guardianships, with roughly 3,200 cases in Palm Beach County and 50,000 cases statewide. A considerable amount of money is managed by guardians. I've personally monitored cases involving over $100 million in assets and one with a staggering over $800 million. The potential for financial abuse is immense. Florida clerks are independent from the court, which creates a vital system of judicial checks and balances. We audit and investigate guardians, and we make recommendations to the presiding judge. Our work helps to warm the bench, providing the court with crucial, verified information so that judges can make better informed decisions. When I was first hired in 2011, my directive was to fully apply professional auditing and investigative standards to guardianship monitoring. At the time, I traveled the state benchmarking our processes and asked judges and clerks, what type of fraud are you observing in your circuit? The typical response was either silence or the assertion that there's no fraud in my court. Now, as a fraud investigator, I knew this couldn't be true. Fraud exists wherever humans, money, and power are intertwined. Then I'd ask, what steps do you take to ensure there's no fraud? The answer was almost always the same. We don't do anything specifically. And this is a critical takeaway for any system. If you're not actively looking for fraud and have no processes to follow up on red flags, you're not going to find it. The absence of the findings doesn't mean the absence of fraud. It means a failure of oversight. A failure of oversight creates fertile grounds for unethical conduct and financial exploitation. One of the first things we did in Palm Beach County was create a dedicated guardianship fraud hotline, a first of its kind in the nation. This allowed us to receive complaints and red flags directly from concerned citizens and family members. Since 2011, we've received over 1,700 such reports. These hotline complaints, along with other risk factors, trigger an in-depth enhanced audit or a full investigation. My division handles these higher risk cases, while other staff within the clerk's office audits 100% of the guardian's reports filed. Our enhanced audits are focused on professional skepticism, objectivity, and diligence, digging deep into the guardian's conduct. In every investigation, I assess two things. First, was there a statutory violation? And if so, was there control environment deficiencies? There is a direct and undeniable correlation between these two factors. A weak oversight and monitoring system enables and attracts problematic guardians. A lax control environment doesn't just create an opportunity for unscrupulous guardians, it actively invites the conduct. Our approach was immediately successful. We identified egregious behavior, unethical conduct, and fraud, which led to arrests of guardians and referrals to the Florida Bar for disciplinary actions. We weren't only catching bad actors, we were creating a deterrent and holding everyone in the system accountable. This best practice we developed in Palm Beach was codified into state law in 2014, allowing all Florida clerks to permissively go beyond basic accounting audits. The law now expressly allows for investigative processes, including interviews and subpoenas. The overall guardianship control environment was tightened up, and professional guardians, family guardians, attorneys, trustees, everybody in the system was all being held accountable. Despite these oversight improvements, we began to see a new problem. Some professional guardians began venue shopping. They would leave our county with its stronger oversight and seek to move a case to a neighboring county without it. This problem highlights one reason why the legislation you're considering here in Michigan is so important. By requiring state licensure, you are leveling the playing field in instituting structure, uniformity, and consistency throughout the entire guardianship system. This will be an effective preventive control to help mitigate fraud. At the very least, bad conduct will be handled consistently regardless on which court jurisdiction it occurs in. The lack of statewide uniformity that we saw in Florida put our system under intense public scrutiny in 2015, with the media publishing anecdotal stories of corruption that even involved a judge and a spouse, a professional guardian, right here in my own backyard. This crisis led Florida to create a new statewide oversight agency in 2016. For 8 years, I was appointed the state's first chief guardianship investigator, and my office oversaw the investigations of about 2,600 legally sufficient allegations of wrongdoing by professional guardians. Our investigations substantiated about 13% of the allegations. While many were minor violations of statute, some were quite severe, including grand theft, elder exploitation, and even manslaughter. The case that inspired the Netflix movie I Care a Lot has its roots in this investigative finding. The Palm Beach County judge's wife was, in fact, the first professional guardian to have her registration revoked. The state's oversight of professional guardians was a necessary addition, and it bolstered local court oversight. The local judges now know there is a state agency that can step in if there are problems not addressed properly at the local level. Over the years, we've seen more than a few bad apples in Florida. 9 professional guardians have been arrested, with more arrests pending. In my experience, the vast majority of bad guardians are enabled by a complacent local control environment where local monitoring is weak and the court disregards the bad behavior. Although the largest portion of guardianship fraud stems from a family member as a perpetrator, the one bad professional guardian is one too many. Even one should not be tolerated, as it disparages all the other ethical professional guardians who work day in and day out in an extremely stressful and often hostile environment. The last professional guardian to be arrested and convicted in Palm Beach County was Linrod Douglas. He exploited gaps in the system by creating and forging financial documents that conceal over $600,000 in stolen assets from multiple elderly victims. He was caught, convicted, and is now serving a 10-year prison sentence. His case is a powerful example of why strong, consistent statewide oversight is essential. You're not going to be able to stop all abuses, but you can make reforms, keep embracing continuous process improvements, and keep out the vast majority of bad actors from the profession to begin with. You are certainly taking a major step in the right direction today. Before I conclude, I want to take a moment and commend this committee, the bill sponsors, and everybody really in Michigan who's taken a leadership position on these issues. Your proposed packages of bills, I've read them. They're reasonable, they're well thought out, and they're grounded in fact. In my opinion, it seems that they are all good public policy. As this makes its ways through the legislative process, I have 2 suggestions for you and for Michigan stakeholders to consider. First is to consider collecting data on all these improvements once they're enacted as a way to measure their success and as a way to look forward to future reforms. And second, for any Michigan court auditor, investigator, regulatory staff, law enforcement, APS, anyone fact gathering for guardianship decision makers, the judges, agency heads, or prosecutors, I encourage you to look into the upcoming National Investigator Training, specialized education and training classes. Information about our class number 3 in Oklahoma City is on the National Guardianships website. So thank you again for your time. Thank you, Chair. And I am available for any questions.
Thank you very much for your testimony, and it sounds like that system in Florida is wonderful, and you are helping our vulnerable people. So thank you for that, and let's go to Rep. Johnson.
Thank you for clarifying so much. Out of all the fraud and abuse cases that you've encountered over your whole career, what percentage was family members versus professional guardians?
So my statewide role as the Chief Guardianship Investigator only dealt with professional guardians and public guardians. There's roughly 550 state-registered professional guardians in the state. My local role in providing oversight, auditing, and investigative involving the 3,200 cases right here in Palm Beach County. We have a population of about 1.5 million persons, to give you some context. The vast majority of the fraud that we identify involve non-professional guardians, family members, caregivers, neighbors, and the such. As much resources as we dedicate to identifying that type of fraud, we can find it. I used to say it was low-hanging fruit, but I stopped saying that like 12 years ago, because we haven't gone through the low-hanging fruit. It's that easy as a fraud investigator to identify it.
Rep. Bosniak?
One question. Thank you, Chair. Did your system allow for restitution to the families or the ward?
Yeah, so the disciplinary process through the state, it's through, it's an administrative law process, and restitution can be a part of a sanction, if you will, through that administrative process. It can be also through the local court can order sanctions, clawing back ill-gotten gains, ill-gotten assets. So there are different, both from the court's perspective and from the state's perspective, in which there are opportunities to seek restitution. I think fraud investigators, regardless on the type of fraud, will agree. Once that money is misplaced and taken and controlled, it's very hard to claw that back to get restitution. But we do try quite a bit for the victims.
Thank you very much, Anthony, for being here to testify. We appreciate the information. Thank you.
Thank you.
We have some cards to read in. Kevin McKinney, Michigan Brain Injury Provider Council, supports the bill. Alan Bolter, Community Mental Health Association of Michigan, supports the bill. Kevin McKinney, Coalition Protecting Auto No Fault, supports the bill. Danielle Serino-E, something like that. Michigan County Social Services Association supports the bill. Richie Farron Healthcare Association of Michigan supports the bill. So we appreciate all that support. Rep. Thompson excuses absent members without objection, so ordered. We have no absent members, so that's good. Thank you for everybody always showing up for this committee. That is really good, and it's important. There being no further business before the committee will stand adjourned.